Good afternoon, everyone.
Good evening.
Good evening. Yes, it's after 6 this evening. I apologize.
Good evening.
Good evening. Oh, more enthusiasm.
Good afternoon, Miss Acha.
Good afternoon. How are you?
I am great. How are you?
I'm great, just like you. All right. I got one written of the questions we did last week.
Questions.
I got one. That's fine. I'll look at it and provide some comments.
Zaj, I thought we were actually gonna read them in class.
What, the work we did last week?
The review. I mean the cases you gave us to.
Oh, no. I wasn't talking about the cases. I was talking about the questions, the contract questions we went over last class. Someone actually wrote out their answers and sent it to me.
Oh, okay.
Not that, no.
Okay.
I didn't mean that. All right, so we ready? Some people missing. Some people are missing. So let's get started then. So who wants to start the recap from the beginning? So that when we start chapter 4 now, we have it in context. Anybody can start. From the beginning. And put it in context of banking law. You want me to start? I can start and then you can join in. How's that? Good? So we started off our studies on banking law by looking at the legislation that governs banking business in the Bahamas. So we first started out with the regulator, which is the Central Bank of the Bahamas. We looked at the Central Bank Act, just glanced over it. Then we went in particular to the Banks and Trust Companies Regulations Act, which was just passed in 2020. We then looked at deposit insurance. We looked also at the Financial Transaction Reporting Act and its regulation. In particular, when we looked at the duty of confidentiality, it ties into the Data Protection Act. We also look at the Anti-Terrorism Act, and we also looked at the Computer Misuse Act, which goes into different acts of misuse of computer that can be tied to the Data Protection Act. So from there, next person, what did we cover? Who's taking the stab at chapter 2? Nobody?
We went over contract law. The different.
Sure.
We went over the different steps. What makes how a law is formed.
Yes.
And the different steps they go through, how it would become a bill and all of that.
How a bill becomes an act.
Right.
Right. And we learned that there are different rules when a judge is reading a legislation, or even when you look at a case, and the cases of what you looked at, you'll see that the judge goes and he looks at the facts, he looks at the issue, then he turns to the law, and then he applies it to the case. So you learned that. And you learned that there are certain rules of interpreting the legislation itself. You learned that there was the literal rule, the mischief rule, the justum generis rule. So we went all through that. Then we went to chapter 3. So, okay, what's chapter 3? Sydney, since you on a roll, continue. What's chapter 3?
Chapter 3 is actually contract law, where we went over basically the different steps that make a contract, like the offer, acceptance, consideration, the capacity, and the intention to create legal relations.
Yes. And what else you learned about a contract?
The offer and the offerer, offeree, acceptance from both parties, consideration being cash or a service.
Mhm.
How to exit a contract, and then ways in which someone, I guess, can sue, or if they're an aggrieved party, how they could seek for damages, and for sums of monies.
And remember, we also spoke about legal capacity, whether or not the person has the capacity to enter into a contract. So that's something also you have to look at. And remember, one of the key things is that there is privity of contract. So only the parties to the contract, those who can enforce the contract. So that's also key. And you need to remember that. And then the last thing we looked at last week was what? The one where you took your notes. You remember? You would have done a table and you looked at the law of contract versus the relevance of it to banking. Recall? No? Yes?
So,
All right, so let's start chapter 4, which is the banker-customer relationship. And when you talk about the banker-customer relationship, that could be a person who opens up a savings account, a checking account, a person who is coming for a loan, the person who's just getting a credit card, or a person who is on the wealth side, who is maybe have some securities that they want to use as collateral. There are many different ways in which a person can become a customer, because it depends on the products and services that they're seeking to get from the company itself. So whenever you talk about the banker-customer relationship, one of the key things you have to think about is, what is a bank? So who could answer that? What is a bank? Whoever had the case of United Dominion versus Kirkwood should be able to answer that.
I actually had that one, Miss.
Okay, okay.
So a bank is let me get my notes.
In the common law case of United versus Kirkwood, I had to make the distinction now, so everybody know that you're reading from a case.
Okay. So in the case of United Dominion Trust versus Kirkwood, so in this case, we would have the plaintiff being United Dominion Trust Limited, the defendant being Kirkwood. So some of the facts of the case would be Kirkwood was the endorser of 5 bills of exchange of $1,000, each drawn on UTD, which is United Dominion Trust, in 1961 on L Limited, a motor trading company. The bills of exchange were the only security for several loans between UDT and L Limited by way of stocking finance. Stocking finance is a method of credit used by car dealers to help them stock their businesses with vehicles. In 1963, L Limited went into liquidation and all the bills were dishonored on presentation. The defendant, Kirkwood, received due notice of dishonor UDT was not registered under the Money Lenders Act 1900. Therefore, any loan contract should be deemed unlawful. The defendants feel like they should have a banking institution. They should be treated as a banking institution, provided that they were doing business incorrectly. The decision of the Court of Appeal has largely been superseded for banking regulation purposes in terms of defending what constitutes a bank. And a bank would be considered a company that performs day-to-day transactions and not limited to deposits, withdrawals, term deposits, the issuance of debit cards, but not solely. In this case, how United Dominion would have handled their business, being that they only used bills of exchange.
All right. So if I were to ask you now, as an exam question, to define a bank, how would you answer that?
I'd say, like I said, a bank is
You could reach out for a lifeline. Ask someone in class to see if they can help you. How would you answer that? What is a bank?
I guess I'll call a bank a financial institution that accepts and offers deposit services, account services, loans, and I guess financial advice.
Okay. Anybody else?
I guess you would say in the case of United Dominion Trust, and click what a bank is, and then go from what they name a bank.
Yes, you start out with the common law case and then you go to at the where?
To the ruling or the judgment. I mean,
Well, in UDT versus Kirkwood, what they said is that the essential characteristics of a bank at that time was collecting checks, like he said, paying checks, keeping current accounts for their customers, and of course, having the reputation of a bank in the community. Now, this was 1966. And this is how law works. Law works based on what's happening in society. So in 1966, that case of UDT versus Kirkwood gave the definition of a bank. Today, in the Bahamas, a bank is defined as what? How do you know what is a bank? How would you know?
it's a financial institution that I know there's a bank because it's a financial institution. It accepts, it does financial transaction, savings, loans, checks, cashing checks, depositing, and those stuff. That's how I know what is a bank.
Okay, so go ahead.
And then I know it's a bank because it is registered at a bank as a bank.
And in order to be registered as a bank, or should we use the correct word, to be licensed as a bank, what is required?
Approval from central bank.
Yes, you need to get approval from the central bank. But more than that, let's just say we open up a business now and we're doing certain activities. what makes us a bank?
I guess we have to have the financial backing.
Mm-hmm. You see, all you all are running around, skirting around legislation. This is why legislation is important. The Banks and Trust Companies Regulations Act does not define what is a bank. Rather, it defines the activities that a company carries out. And that's what makes it a bank. The same way UDT listed collecting checks and paying checks and keeping current accounts. And then it added to that you must have a reputation in the banking community. The Banks and Trust Companies Regulations Act Section 2 tells you a bank means any person lawfully carrying on banking business, including the accepting of deposits of money withdrawable by check. And then it goes and it defines for you what is banking business in the definition. Recall that? When we started out and we went through the Banks and Trust Companies Regulations Act.
Okay.
And so 20 years from now, or maybe even 15, the definition of banking business may change because it changes over time. And is based upon what is happening in the community. So similarly, the Banks and Trust Companies Act gives you the definition of bank. It gives you the definition of banking business, but it also has expanded over time the definition of deposit. Because remember, I told you that a bank is the accepting of deposits of money. And so the Banks and Trust Companies Regulation Act actually defines for you what is deposit. So if someone was to ask you, what is the definition of a bank? Your answer would be, in the common law case of UDT versus Kirkwood, it was established that a bank is an entity that collects checks for customers, pay checks drawn by their customers. They keep current accounts for their customers, and they would also have a reputation in the community as a bank.
Mhm.
However, in this 21st century, in the Bahamas, the Banks and Trust Companies Regulations Act, Section 2, defines a bank as any person who is lawfully carrying on banking business. And that includes accepting deposits. And then the act then defines for you what is banking business. And that banking business is one of the criteria for you to meet the licensing requirement to be a bank. So that's why you see some people will come and they will start up a business and they will lend money, but they don't accept deposits. So once they're just lending money, then they fall under the Money Lending Act, which is regulated by the Securities Commission. When they start accepting deposit, then they will fall under banking business. Any questions? Okay, so we know what a bank is. So now let's go and define what is a customer. And the first case you see is the Commissioner of Taxation versus English, Scottish, and Australian Bank. Did I assign that one to anybody? I don't think so. So in that case, a certain A friend for payment of an assessment of income tax, drew some checks from himself, and he put it in an envelope along with some other checks from his family. He addressed it to the Commissioner of Taxation and directed his clerk to deliver it. His clerk delivered it by keeping it in a box kept for the purpose of receiving letters. Mr. Friend followed instructions given in the assessment notice and made this payment by remitting the check crossed to the Commissioners of Sydney. However, this envelope was stolen by someone and the check was not cashed in by the commissioners. A man approached the respondent bank and stated that he wished to open an account. He gave his name as Talon. He gave an address and paid in £20 into the account. He also asked for a checkbook. The next day, Talon comes to the bank with the stolen checks and asks to be credited. This was done, and subsequently, persons with 3 checks drawn by this man came in with an order signed by the man to pay. The man was not seen again. And in this case, it was decided that anyone who opens an account, whether they are a rogue or they may be an angel, they are a customer of the bank for statutory protection. Even a foreign bank that sends in a check for collection within the jurisdiction is also a customer for that purpose. So central to that banker-customer relationship is a contract. And that contract itself is written, and it has express terms and it has implied terms. And we'll get to the implied terms later. So a person may only become a customer of the bank when the contract has been made with the bank. So how does a person become a customer? Anybody knows? How does a person become a
Do you become a customer by opening up an account or depositing money in that bank?
Now I want you to think when you answer in terms of contract law. Say it again and think about the elements of a contract. When does a person become a customer?
I mean, but with opening an account, what you have to fill out an application to that bank. You bring in your IDs, all of that. They record all of that. Wouldn't that be a sign of a contract?
Yes, but I want you to say it in your mind, whereby you can align the elements of a contract with opening a bank account and a person becoming a customer. So let me explain. When a person walks into a bank, they come to you and they say, I want to open a savings account. I want to open a checking account. So what do you do then? Don't you sit down and explain to them the type of accounts that you can offer them? That's the first step, right?
Right.
Okay.
Yes, ma'am. Right.
So that's an invitation to treat.
Okay.
Right? Then that person listens to what you have to say and they say, okay, I think I'll open a savings account. You'll ask, how much do you have? How much do you want to open it with? Okay, the minimum is $100. And the person say, okay, I have 150. I want to open the account with 150. That's an offer. Then you say, in order to open this account, you need to give me your IDs, your address verification, and you need to fill out this form. So they do all of that. Then you go and you take the form to have it approved or whatever the next step is, and you come back and you then take them to the counter in order for them to open the account, and they give you the 150. That's acceptance.
Mhm.
Now, when you take that person's ID and you look at that person's ID, which part of the contract is that? What are you looking for then? Intention to create legal relations. Are they 18 years or older? Because if they're not, then you need a guardian.
Mhm.
And that's why last week we looked at contract. Because when you enter into a bank and you start to fill out that form or start to ask questions, that process is beginning where you're about to enter into a contract. Because once they sign that form, they are bound by the terms of that contract. And then, like I just said a few minutes ago, in addition to the terms in that contract, there are some implied terms. And implied terms mean that those terms arise by law, just because you're dealing with a bank. So the banker customer contract begins when the customer's offer to open an account is accepted by the bank. The decision in Woods versus Martins. Who was Woods versus Martins? Nobody? No? That held that a bank may owe certain duties to a person even before they become a customer of the bank. And that could be where the bank accepts the instructions to collect money for an account before it happens. So someone may come and say that they're opening an account or they're doing a transaction, but the funds are to be wired in from another bank. So that person will become a customer even before the consideration is received. So even if the bank provides advice to a person, by law, there are certain duties. Because if you give advice to a person, even if that person doesn't have an account, and that person relies on that, and they suffer loss, they will sue for negligence. And that's the case of Headley Byrne. So there are some exceptions to the banker customer contract. If someone just merely cashes a check for a person who doesn't have an account with the bank, then that person is not a customer. And you know, now in this 21st century, we don't do cashing of third-party checks. Also, a customer is considered a customer of the individual branch where he has his account, not the whole bank. So under the banker-customer relationship, there are certain ground rules that you must remember. First, that relationship is contractual. Next, once you enter in that relationship is a debtor and creditor relationship. Who had Foley versus Hill? That's you, Ellen.
Yes, ma'am. Yes, ma'am.
All right. Explain to them Foley versus Hill.
In the case of Foley versus Hill, let's see. Foley, the case facts was Edward Thomas Foley and Edward Scott. They own Staffordshire Collieries. they had opened a joint account with the defendant bank. And they transferred into the account of the, they transferred from that joint account to a separate account in the sole name of Foley in April 1829. The bank replied with a letter enclosing the receipt and agreeing to pay the 3% interest on the amount deposited. From 1829 until 1834, when the joint account was closed, Foley's share of the colliery's profits was paid by checks drawn on the joint account by the colliery's agents. These checks were paid in cash or in form of bills drawn on their London bankers in favor of Foley. The issues were, in January 1838, Foley filed a bill in equity against the bank, claiming that an account should be taken not only of the initial deposit, but also of all other sums received by the bank for Foley on its private account since April 1829, with interest at a rate of 3% per annum, and also on account of all sums properly paid by them for or to the use of Foley on his said account since that day. Customer paid money into an account expecting to receive 3% interest per year, but wasn't paid any for 6 years. He wanted them to give the profit they made on his money. The judgment was that when money is deposited in a bank, it ceases to be the money of the principal and becomes the money of the banker, who is obligated to return an equivalent by paying a similar sum to that deposited with him when asked for it. The money paid into a banker's account is money known by the principal to be placed there for the purpose of being under the control of the banker. It is then the banker's money. He is known to deal with it as his own. He makes whatever profit he can out of it, which profit he retains for himself, paying back only the principal according to the custom of bankers in some places, or the principal and a small rate of interest. What is significant is that although the principle that the relationship between banker and customer was one of debtor and creditor had been applied in several previous cases, this was the first time that the House of Lords, as the highest court in the land, has affirmed the position.
Okay. So Foley versus Hill established that once you put your monies in the bank, that is a debtor-creditor relationship. The bank becomes the debtor to the customer. Creditor upon the bank becomes the debtor to the customer, and the customer is the creditor. Because the deposit, when you look on the balance sheet, is on the liability side. So, however, the bank is liable to pay monies deposited to the customer upon demand. And that's what Mr. Foley did. He demanded his money.
Right.
Now, whenever you owe money to the bank, then the roles are switched. You then become debtor and the bank becomes creditor. So again, the banker-customer relationship is contractual in nature. Second, it is a debtor-creditor relationship. Third, it has express and implied terms. And those implied terms is where you find the rights and the duties of the bank and the customer. And those were established in the case of Williamson versus Swiss Bank Corp. Who had that one?
I had that one as well.
Okay, all right. So tell us about Williamson. Joachim's.
All right, so that one was. All right, so the parties involved were the firm and Joachimson, consisting of Siegfried Joachimson, Jacob Joachimson, and Ellie Marks. The law firm is considered the plaintiff in this case. So Siegfried Joachimson and Jacob Joachimson were Germans, and Ellie Marks was a naturalized British residing in England. So the facts of the case are the three gentlemen jointly operated a bank account with the Swiss Bank Corporation. Siegfried Joachimson died on August 1st, 1914. And in this case, due to the English partnership law, meant that the partnership should have been dissolved due to the death. J. Joachimson returned to Germany due to World War I. In an attempt to wind up the affairs of the partnership, Ellie Marks tried seeking repayment of the sum held in the bank account. The bank refused to repay due to no demand being made by the firm for repayment. Therefore, they were not considered due. The bank also refused to pay due to the right of repayment only arose when Siegfried Joachimson's debt, which was now barred by statute of limitation. Statute of limitation being the length of time in which the parties to a potential lawsuit can initiate legal action before the dispute in question is considered too old to be litigated. So the result, the Court of Appeal held unanimously that the claim was not statute barred until a customer demanded repayment from the bank. The debt was not due and payable, and thus period of limitation was not run. The court ruled that there was no obligation to pay money on the account until after it had been demanded.
So you see now, when someone comes to a bank and they demand their funds, by law, they can't do that, by banking law. Because that's when time begins to run. So Joachimson, in that case, what you just gave us was the facts of the case. But that case actually went even further, and it laid out the duties of a bank. And coupled with other common law cases, they've come up with these duties and rights of the bank and the customer, and some of which are actually stated in the account opening documents. And then some are implied. So as a banker, you should know the duties of a bank. You should know the rights of a bank. You should know the duties of a customer, and you should know the rights of a customer. So let's start with what's the duty of a bank. The duty of a bank is to receive money, deposits from the customer. And you know that, because that's a part of the definition of being a banker or being a bank and in banking business. The second one is they have to collect and comply with checks written on the customer's accounts. And that requirement to comply with what's written on the check is only if there is sufficient funds in the account or an overdraft has been authorized. Secondly, they can only pay a check if it is properly drawn up and is not forged and is not stale dated. And thirdly, you can only pay a check if there is no countermand. That is, there's no stop payment on that check. So the bank has a duty to cash your check unless one of those three things has happened. Another reason why they probably will not cash your check is if the customer has died. Because once the customer dies, the contract is at an end. The other duty of a bank is they have to repay the customer's entire money on demand. Once a customer comes to their balance or in their account, By law, the bank has to give the customer their monies. And that normally should be done within banking hours unless it has been prearranged. And remember now, if you go beyond banking hours, then you put the bank at risk because the insurance only covers certain hours for certain operations to take effect. The next duty of a bank is that whenever it is closing a customer's account, it has to give them reasonable notice. And reasonableness depends on the type of business that the customer is in. So you see a lot of banks would have gotten into a lot of trouble with the regulator when they decided to close accounts and didn't give the customer sufficient time to find another bank in order to carry out their banking business. The fifth duty of a bank is that preservation of confidentiality. And we're going to talk about that next week. As a banker, by law, you cannot disclose a customer's information to anybody. Remember when we spoke about the contract? One of the elements I told you of the contract is what? Privity of contract. So unless that person is a party to that contract, you cannot disclose any information. And then there are 4 exceptions, but we'll do those next week. The next duty of a bank is to provide a statement of account to the customer periodically. Although the customer is not obliged to check the bank statement for errors and omissions. Now that's the common law case. In one of our classes going down, because I'm going to give you enough time to read those 2 cases I sent you. McCushla versus Scotia and Scotia versus Cushla, Pinder. And you will see how the bank in its terms and condition states something different. So I need you to start reading those 2 cases so we can discuss this whole point about whether or not a customer is obliged to check the bank statement for errors or omissions. And the 7th duty of a bank is that you have to exercise the proper skill and care once you're carrying out a customer's instructions. And that's why you're here in class today. Because bankers are placed on a higher pedestal than other persons in different professions. As a banker, it's expected that you know the principles of banking. And it's expected you would know what are the duties of the bank. And you should know what are the duties of the customer. So after you've looked at the duties of a bank, then you have to look at what is the right of the bank. What can the bank do? The bank can charge fees as long as it's reasonable. And of course, under the Banks and Trust Companies Regulations Act, it says what? They have to give notice. So the bank, as long as the fees are reasonable, they can change their fees every 6 months, every year, as long as it's reasonable and as long as they give adequate notice. They have a right to demand payment for any loan that they've granted, or even an overdraft. They have a right to exercise a lien over the customer's securities. but not things that are held in the safety deposit box. And you see now that a lot of banks are moving away from safety deposit boxes because it's not a money maker. It is also the right of the bank to be reimbursed by the customer for any expenses or any liabilities. They can automatically just take it from your account because that is their right. They have a right to return unpaid customers' checks if there is insufficient funds. They also have the right of set off. And they also have the right to combine accounts. So let's look at what are the duties of a customer. The first duty of a customer is they have to pay the fees. If you don't want to pay the fees, then what do you do? If you don't pay the fees, what do you do? If you don't want to pay the fees?
Close the account.
Close your account, okay. So your first duty is to pay your fees. Second one is to issue checks only if you have sufficient funds. Or if you have already agreed for an overdraft facility. And of course, you have a duty as a customer to make sure that your checks are drawn properly and that there's no fraudulent activity, no forgery. And of course, you have to advise the bank of any known forgeries. So what are the rights of the customer? We know they have the right for repayment of funds deposited on demand. They have that right. They also have the right to have the bank discharge its duties to the customer. So we started off by saying these are the duties of the bank to its customer. On the customer side, they have a right for the bank to carry out those duties on their behalf. And they also have a right to have the funds deposited, appropriated to a specified account to cover checks the customer wants to pay. So let's look at appropriation of accounts. A customer has the right to appropriate payments to a particular account to cover certain checks. But when the customer doesn't specify, the bank has the right to do it themselves under the rule in Clayton's case. And that rule states that where a continuous running and unbroken account exists with payments, both in and out, if there are no other instructions, and the person making the deposit to appropriate monies paid in a specified account, the credits are appropriated to the debits in date order. And that's where the account is overdrawn. If it's in credit, then the debit extinguishes the credits in date order. But sometimes that rule can work to the detriment of the bank. So say upon receipt of a notice of a subsequent mortgage, when the bank is the first mortgagee and the customer's accounts are overdrawn on that date. Or let's say they get notice of death, mental incapacity, or bankruptcy of a joint account holder, and where the joint and several liability has been established and the account is overdrawn. Or where guarantor gives notice to determine his or her guarantee. When these situation arises, the bank closes the account and opens a new account. And they do that so they can prevent the rule in Clayton's case operating to their detriment. Because if they don't do it, then subsequent credits will reduce or repay the borrowings outstanding. And then the debtors will create new borrowings. And then those new borrowings will be unsecured. So like I said earlier, the banks also have a right to combine accounts. So where the customer has two different accounts with the same bank, without even giving notice, even if they are different branches, they can combine accounts. And where there are 3 or more accounts, the bank has the discretion to combine any accounts of its choice. But of course, that right to combine has limitations. So where the debit balance is on a loan account and is presently due and payable, as there is an implied agreement under the banker-customer contract to keep the accounts separate. And this could be where the customer shouldn't have their checks dishonored without a warning. And they can make that arrangement with the bank. Another limitation is where the debit balance account is not yet debt due and payable by the customer. So the loan account, which is payable in a future date, cannot be combined for customers' potential liability as a guarantor. And of course, if you have an express agreement not to combine the accounts, then the bank cannot combine the accounts. And where one account represents funds held on trust by the customer, and the bank is aware that those funds are held on trust, then they cannot be combined. And that's another point that you have to remember. When someone applies for a loan or a facility, and they say that those funds are earmarked for a particular project, that customer cannot use those funds. Because what can happen is that the person whom they have contracted with, when they start whatever business it is with that customer, and the customer is unable to pay, and they are aware that that customer went to the bank for a facility and was granted a loan for X number of dollars to cover that project, and the bank allowed that customer to withdraw those funds, that person can sue the bank. Because the bank had knowledge that those funds were earmarked for a particular purpose and to a particular company or person. Any questions so far? So safe custody is a service that, like I said, a lot of banks are coming out of it. Even this week in I think in the US news, some of the banks are also doing the same thing we're doing here, saying that they're getting rid of all of these safety deposit boxes. And so now people have to find another way to store their jewelry and stock certificates and bonds and whatever other valuables that they have. Now, whenever you talk about safety deposit boxes and items held in safe custody, that falls under the contractual arrangement called bailment. And bailment means when one party holds or they possess the property of another person for safe custody. And you could either do that for free or you could do it for money. But it always has some implied terms and condition. So under the banker-customer relationship, the customer is the bailor. So the bailor is the person who brings in their goods to be deposited. The bailee is the bank. Now, under the bailment, a customer always retains ownership of those items. So there are two types of bailees. Bailee for reward, they are paid, and gratuitous bailees, they are not paid. So generally, the bank is considered a bailee for reward because you have to pay in order to maintain safety deposit boxes. The decision in the case of Port versus Wu established the principle that a bank is always regarded as a bailee for reward, whether or not is specifically paid for the service. So liability under a contract of bailment is considered under two areas. The bailee's duty of care, because remember, a banker is held at a certain standard. He should have the proper skill and he should carry out his duties professionally. So under the liability under contract of bailment is the bailee's duty of care and conversion. So what's this duty of care? Bailees are liable for loss, for theft, or damage. The property held in safekeeping. And remember, because it's a bank, they're held at a higher standard. So it's expected that if you take persons' property and you are holding them in safe custody, you should know how to maintain those property in a safe manner. So a bank may be found liable for breach of contract if it negligently allows the items to be stolen or damaged, even if it's done by the employees. The customer can still sue the bank. Conversion is when it can be an employee or it can be someone who comes in to purport to be the owner. They can commit the tort of conversion. And that can happen when you refuse to deliver the property upon the request of the customer, or you won't deliver it. Or you give it to the wrong person. And now the actual owner is before you asking for their property. So a bailee for reward must take extra caution to ensure that the environment and the surroundings where the items are placed in safe custody are safe and secured. So let's just say someone has a painting. It's not in a frame and they've rolled it up. And just put elastic band around it. And they put it in the safety deposit box. And then when they come back, they find it's full of mildew and water stain. What do you think is going to happen?
Sue the bank.
Or under the banker customer contract, they will sue the bank for damages. They will sue for loss. They can sue for all kinds of different things. So always remember now, goods that have been placed in safe custody are not subject to the banker's lien. So if a person has a loan, you cannot put a lien against what's in the safety deposit box. So a banker's lien is a special type of lien and is equivalent to an implied pledge and carries a power of sale. So a bank can ordinarily have a lien over securities or share certificates or bonds. So that a banker's lien is different from bailment. So safe item is being deposited for safe custody by 2 or more persons jointly. Delivery of the item should only be made on the authority of all of the bailors, not just one. It doesn't matter what the relationship is. The bank can take instructions from joint bailors that any one of them may obtain receipt of the property once demanded. And then, of course, on the death of one of the joint bailors, the right of survivorship exists for the surviving bailor or his personal representative. So whenever it comes to bailment, that contract should be written unequivocally whereby the bank is protected against potential liability. Now, a bank may refuse to return items in safe custody on demand and detain such items for a reasonable time if it has some uncertainty or doubt as to who actually owns the property. And a bank will only be liable for safe custody being stolen or lost or damaged by its employees under the tort of vicarious liability. If the employee was acting in the course of his employment by performing his duties, even if he's doing so dishonestly. An employee's duties may have included supervision and security of the safe custody items. Of course, if the employee was acting outside the scope of his employment, then the bank may not be held liable for the actions of the employee. But it could be argued that the bank may still be liable for breach of contract on the grounds of negligence by permitting an unauthorized employee access to the items in safe custody. Or the customer can sue the bank for negligence for having a dishonest employee. Another thing you need to remember is night safety deposit boxes, the chutes that you put the monies in. So customers who avail themselves of night safes are required to enter into an agreement with the bank that provides that the relation of banker and customer for the deposit doesn't arise until the wallet is opened, either by the customer or his agent or the bank on the customer's behalf, and deposited in the ordinary course of business. So normally they say that before that money is counted, when the money just goes into the chute, that's normally in banking, that's under a bailment arrangement. And it's unpaid, so it's gratuitous. So the banker-customer relationship may survive indefinitely. Only the banker-customer contract may terminate. And the banker-customer contract can terminate in 3 ways. by the customer himself. And the customer can do that when he demands that he wants the funds that are in credit on his account. And once a customer withdraw all their monies to zero, then they automatically close the account. The second way you could terminate an account is the bank can close it. And of course, remember, the bank can only do that by giving reasonable notice so that the customer can make the appropriate arrangements to have a facility at another bank. And reasonableness, like I say, depends on each customer and the nature of their business. The third way a customer-banker relationship can end is on the death of the customer. Or if the customer becomes mentally incapacitated, or the customer is bankrupt, or the company is insolvent. And those are the three ways in which a banker customer contract can be terminated. Any comments? I hear nothing. Everybody's quiet.
Well, straightforward.
Wonderful. I like that. Okay. I'm going to ask you all 5 questions, and you're going to get homework tomorrow. And I expect to see them written and sent back to me. So let me see what I can ask you. I don't want to make it too hard. Okay, let's see. I'm going to call any name. Don't worry, I'm trying to find something that's not too hard. Okay, without looking in your notes now.
Well,
Yes, don't look in your notes. Nadia, what is a Bailey? I hear paper turning.
Huh?
I heard paper.
You read paper?
Yes. Go ahead, go ahead.
What is a Bailey? That's the question.
Yes.
Bailey is a can I refer?
No. You mean to someone else?
Sorry?
To someone else?
Yeah.
You ain't start, yes.
I know, but
What? Okay, that means I'll have to come back to you or someone will call you. Go ahead.
oh wow.
Go ahead.
Go ahead and refer is what you said to me.
Yes, you can refer.
Okay. Anybody?
Call a name. Don't say anybody.
Okay. Let's go with Davisha.
Okay, Charlton.
A Bailey is a person that is paid to hold the valuable items. I guess the person that the items are placed in their custody for safekeeping.
Yes. Okay. You see how easy that was?
Awesome, awesome. You following?
All right. So let me put this question to Capron. In the event of the death of a customer, at what point is the bank's authority to pay checks terminated? Repeat it.
No, Mom, you don't have to repeat. I don't think I know the answer though.
What? No, no, don't scream.
We just,
We could reach out to someone.
What's the question? I didn't hear the question.
In the event of death of a customer, at what point is the bank's authority to pay checks terminated? In the event of death of a customer, at what point is the bank's authority to pay checks terminated? Why have silence?
I would think upon their death.
Is it by the time they receive a death certificate and or the next audit, successful audit, or no?
Audit, how you get audit?
Verification process? I don't know, I just going by my banking standards. Sorry.
No, yeah, but explain that to me. Explain the audit part to me.
I know from watching people, they would come in for verification purposes after a certain point, something like that.
Oh, that's what you meant. Oh, okay,
Yeah.
okay.
Oh, right, the expiration of the check-in log on and or book. I think them books of the check, they have expiry date, right?
Yeah, but hold on. I say in the event of death of a customer, at what point is the bank's authority to pay checks terminated? So let's say the person croaked yesterday, but checks are still coming in. Do they clear those?
If there's sufficient
Only
funds, as long
would
as
think
the
they-
bank wouldn't know. So as long as their certificate doesn't come in, I assume they would pay it.
Okay, someone else was saying something just now. Let me hear that.
I think they would pay until they have knowledge of the debt.
Mm-hmm. Yeah, and how do you get knowledge of the death? See, this is the key part.
When the death certificate is presented.
What'd you say, Lorenzo?
When the death certificate is presented.
Yes, but you could have knowledge of the death before that.
Yeah, sometimes the newspaper,
Yes.
sometimes you get information that someone died from family members.
Yes. And so you always, in banking, first thing, because I know a lot of you all don't do it, because that's the new generation. Y'all stay on social media, but you have a responsibility. What happened?
No, I have a local worker that does it every Thursday.
Exactly. Doing it. They're not doing it to look to see who did for looking sake. You're looking for your customers.
Mhm.
That's what you're looking for, because you could have someone who could come right in there and pretend to be that person, or the family member can come in and start to draw off funds. And people do try to do it.
Gotcha. In an instance like that, like if you find your customer passed away via social media or something like that, I guess it's different for every banking institution, but how do you put a stop declaring the checks coming onto the account without the proper documentation to upload to the customer's account for the file?
Okay, so let's just say a family member advised you that a person passed away.
Right.
That would either be on the ZNS News, and you advise your compliance department that Mr. So-and-so, I heard it. I was reliably informed by the family member, and I also saw it on ZNS News this morning that Mr. So-and-so passed away yesterday.
Right.
And then that account is flagged. So when transactions, if someone come in to do a transaction, then the question will be raised because they know that the person is deceased. If you leave the account open, then people will be moving funds.
I guess, but that's if they have access to the funds, though. But like I said, I
Well-
guess it's different for every banking institution because where I work, we don't really allow third-party transactions. So I don't know.
To be third party. Why would you think there'd be third party?
So how would you move funds if it's not a shared account, a joint account or so?
Most of the times they are for these older people.
You mean in the event like ATM withdrawal or so then?
They could do it that way, or sometimes they come in with their niece or nephew and they're familiar with the customer support people, and they come and say, Grammy couldn't come in or Annie couldn't come in today. They know that you always come in with that person, and I just need to draw some money to buy groceries or something. That they draw $500, $1,000. They try to put it within the norm that they always get.
So I guess we're kind of mean then because yeah, we still wouldn't do that.
Everybody is not honest.
Yeah, that's true too.
Not honest.
In other cases, we don't really allow people to come in and withdraw someone else's account either way, like unless their name is on the account or something.
Yeah, their names is beyond the account. But you'll also find out in law too. You can open an account, names can be on the account, and sometimes it depends the purpose for which your name was put on the account. Everybody don't put someone on the account to say, in the event that I die, you just take all my money and go. Some of it is done that in the event that something happens to me or I can't make to pay my bills, I want you to be able to withdraw funds to pay my bills, but doesn't necessarily mean that I'm giving you all my money.
Well, like I say, I guess that's a conversation for the customer, not really for the bank institution where they open the account, because you say you want to add someone onto the account, we just do it at the request of the primary holder on the account, and then those funds are really shared between those customers on the account. So whatever personal agreement they had, I guess that's really on them and not really the institution.
I mean, to interject, when you open up a bank account, they will ask you what type of account you want. Is this going to be a joint account, or is it going to be an account where you're adding a guarantor? I think
Yeah.
that's the
Oh,
term you're looking for.
for us, we just do joints. We don't. No, I've never seen a guarantor.
I think every institution should be able to do it. I mean, if
Yeah.
you're opening savings, yeah.
Mm-hmm. Because like we're saying, it's not always you put someone on your account means that, okay, I have $40,000 on my account. That's all my savings. So I have 60 or 100,000. And I have this lady who's been taking care of me for the last 15 years. I'm getting down now. And I decide to put her on. And I tell her, I'm going to put you on my account so you could pay the light bill and the water bill. Pay my medical expenses if I can't go to the bank or whatever. I'm not giving her all of my money. And you'll see family members will actually take them to court. Because they look at what were the intention of the parties when they open the bank account. Anyhow, let me ask you another question. I had one just now. No. It disappeared. Don't worry, it's coming back to me. I just had it just now. It was one. Yeah, no, not too long. These are past exam questions, you know, so you won't see these on the midterm. I'll have to think of some new ones. That won't be one. Not that. I wanted to ask you a question on minors. What can I ask you on minors? Okay, let me ask you this one then. We talk about this. What is a lien? What is a lien?
Basically, lien on an account and or mortgage, something with an asset. You don't pay your bill, the bank liens on that asset
Mm-hmm.
and or account. They would
Yes.
deduct funds from that.
Okay, so let me ask you that same question in a different way. How would you best define a lien? What's the best way you would define that? If someone asks you to define a lien, what's the best way you would define that?
I would say safety blanket or second option. Security.
Safety blanket or second option.
Yeah.
Mhm.
Liens only carried out.
Yeah, but put it in
Like,
Put it in what type of
bank
term?
terms.
Wait, I thought I was putting in banking terms. I'm missing something. Hold
What?
on.
A security blanket? No.
Yeah.
I would say it's a security.
Collateral? No.
Over a property to secure it until the debt is paid.
Yeah, yeah, you go. That's right.
Way to
You
go,
could,
Ellen.
yes, you can define it as a right.
Mhm.
Remember now, when we talk about the banker-customer relationship, there are rights and there's duties. A lien is a right to retain a person's property until that person has paid the debt. Always remember that in that banker-customer relationship, there are rights and there are duties on both sides. What's a guarantee?
Let's see, let me put this down.
What's a guarantee? You think these polices are making all of this noise?
A guarantee is, I think, when, let's say, for example, someone borrows from the bank, if they are unable or fail to settle a debt that the bank could cover.
Not quite.
Guarantee is when you get something in writing to say that to assure that a debt will be paid, you get something in writing with certain conditions then.
Correct. You're correct. That's what it is.
Right.
You get some type of financial document. So to ensure that in the event that the liabilities of the debtor, to make sure that it will be met. That's what the guarantee is all about. Let me see what else I could ask you. So you're getting a feel of how the midterm questions will be, right? These only multiple choice. I don't think I'll give you all any of these. They're too easy. A contract of loan made to a minor is what? Valid, unenforceable, voidable, or void? A contract of loan made to a minor is what? Valid, unenforceable, voidable, or void?
Voidable?
I think it's impossible.
Avoid.
I get
I
two.
think it's voidable. So
But you can't just give me one word. What you basing it on?
due to the fact that
You
they're
get a
minor,
one.
they don't legally have the right to sign or be in contracts.
Mm-hmm.
So I deem it as voidable.
But didn't we look at some rules?
Yeah, if it's a necessity.
Ah, there we go. If he's getting it for necessaries, then he's going to have to pay. Okay, let me ask you this one. If the bank delivers a safe custody item, remember, an item in safe custody is bailment. So if the bank delivers a safe custody item against a forged authority, you know what I mean by forged authority, right? Someone has a permission letter, but it's a forgery. And they deliver that property to the wrong person. What tort has been committed?
Okay.
You know what tort means, right? T-O-R-T.
Just like a wrongful act.
Yes. So if a bank delivers a safe custody item against a forged authority, they give it to the wrong person, what tort has the bank committed?
I don't know, a breach.
Mm-mm.
No.
We talking this tonight.
Yeah, I know, but I can't remember. You say don't look in the book.
No, don't look at the book.
I trying to don't look at the book. Okay.
Read it, Ms. Archer.
Hey, just gonna ask you to repeat it for me, please.
Okay.
Sorry.
If the bank delivers a safe custody item against a forged authority and to the wrong person, what tort has the bank committed? Remember, tort means wrongful act.
Failed to verify.
No, that's an action.
Conversion.
Yeah, conversion. Correct.
Yay.
All right, let me give you one more. In the context of the banker-customer contract, why is the case of Ternier versus National Provincial important?
Well, I remember the case.
You don't know that that case, we spoke about it when we started out with the banker customer relationship. And I told you that the bank has certain duties. And I said that duty, we will discuss it in detail next class.
Mhm.
So again,
That's he's talking about confidentiality.
yes. Yes. In the banker customer relationship, there is that duty of confidentiality that the bank owes to its customer. Under the Banks and Trust Companies Regulations Act 2020, it doesn't speak about the duty of confidentiality anymore. It speaks to the protection of confidentiality. You see how easy this is?
Yeah, I just gotta think.
Yeah, I know, you have to think.
Mm.
You have to think. All right, what about this one? I said one more, hey. Oh, that was the last one then. Let's go. Which of the following relationships is the essence of a banker customer contract? Which of the following relationships is the essence of the banker customer relationship? Most of them. Listen to what the answers I'm going to give you. Agent principal, bailee bailor, debtor creditor, creditor debtor. Which of the following relationships is the essence of most banker customer contracts?
Oh,
Agent,
the last three.
huh?
The last three.
The last three? It can't be three.
Why can't be three?
It's just one.
Bill, you say
It's
The
agent
debtor and creditor
the
relationship.
debit, yeah.
is debtor creditor
Yeah,
relation.
relationship.
Foley versus Hill. Ellen, you supposed
Paulie
to
and Hill. Yes.
Yeah. Foley versus Hill.
Okay.
Yeah, you can't forget that. And you did the
Okay.
case. Okay.
Okay.
Let me see.
Relationship.
Mm-hmm.
Okay.
If a customer is dissatisfied with the terms of the contract that the banker has presented, where can he go to seek redress?
To the courts.
You sure? If a customer is dissatisfied with the terms of a contract, where can he go to seek redress? Come on, bankers. Come on, bankers.
I think the courts. That's where I go in. After I would have exhausted all other avenues, I go into the court.
Yeah, but you gotta, before you go to the court, what avenues you exhausting before? Let me hear.
I'd say, I guess,
Hmm?
the bank, the
With the
branch.
bank first.
Yeah,
To the creditor.
the branch where you got this product.
You could go to a different bank if you don't like it, the next bank offer it.
You mean if you already in a contract with the bank? Or
You-
already a customer?
You're dissatisfied with the terms. Yes, you don't like the terms.
Well, I'll discuss that with the bank.
Uh-huh. And if you still don't like it, then what?
You close the account.
And then what? Everybody don't just close an account, you know.
You
I don't think.
speaking to after the contract and terms and conditions was already signed, right?
Yes.
Oh, I should read the fine print.
Oh my God. You're rough, you know.
I
Very
mean, if you
well,
don't like the
very
term,
strong
you don't like the
detail.
terms and conditions that the bank is offering you, you could either go to a different bank, you could close your account. I don't
But
know
he
what else
already
you can do.
signed though.
Then you shouldn't have signed in the first place. You should have read
That's
the
what
terms
I'm
and conditions
saying.
before you sign.
You're some rough like this now.
If I sign the contract and I don't like
Banking.
what I'll do, I would make sure go over my contract to make sure that they whatever the terms were was something that they could do. And if it's something that that was lawful in the bank from the bank's perspective, then I just close my account. If it wasn't,
So you all don't have any of those customers who tell you I'm going to the central bank.
No, not really.
Oh.
Oh, yeah.
I thought about that, you know, but then I said, oh, okay.
You're thinking
Go to
that,
the
right?
bank regulators. Yeah, I thought about the central bank,
That's where they go.
but they don't usually do that.
In my days, they used to come often. But then that's a different generation. Your generation will just close the account and go somewhere else.
So, Ms. Archer, what happens when you go? What
When you-
ramifications?
Yeah,
Like how? Like
When you go to,
when
you know?
central bank is flex on people.
Yes, they do. But the first thing they'll do, let's say you come and you have a complaint, whatever that complaint is, you would actually speak to the relationship manager for that bank. They will take a note of your conversation. That matter is then raised. If it's urgent, it is raised with the inspector. If it's something that they think it may be across the board or something that they've heard before, then that matter will be raised at their Friday meetings. And depends on the gravity of what the issue is, it will be raised with the managing directors at their meeting with the governor. So there is redress. It's just that y'all young people is just go from bank to bank. The older generation goes straight to the regulator. Especially if they think some of the practices are unfair, they go to the regulator. And they express it.
So how often does a meeting between the managing director of a particular bank and the governor happen?
I think it's either once a month or every 2 weeks, like fortnight. Yep, it's frequent. You didn't know that either?
no,
Oh,
Yeah.
I didn't know that.
Yep, they meet,
Okay.
they discuss. That's the only way you could keep your pulse on the domestic economy. Because it's not just sending in reports. It's them talking about what's happening in their banks, things that they see happening between them, things that need to be fixed, things that the governor may have heard when he went to conferences, things that the prime minister may have mentioned to the governor that needs to be relayed to them. All right, so I'm gonna leave some of my questions. I think I'll give you all some multiple choice questions on the midterm. How that sound?
Wonderful.
Oh,
That sound-
boy,
yeah,
yeah.
that sound good.
Sounds
That's
very great. I love that.
Okay, so tomorrow I will send you all a homework question, and I need you all to answer me in writing. So type it out and send it to me. And I want you to add cases to it based on this chapter. Okay?
Ma'am.
Yeah, it won't be that long. The question wouldn't be that long. So you don't have to write pages and pages and pages. It's just a one-page thing. Let me just see if
Okay.
you understand the concept. Okay?
Alright,
All right.
alright.
So have a good evening. Those who didn't
Yeah.
read chapter, read it and then read the one for next week also.
Okay.
Okay? All right. So have a good evening.
Okay.
All right,
Good
evening.
night.
Okay, good night.
And,
Good night.